In a 6-3 vote, the Supreme Court sides with the nation's big television and cable networks, ruling Barry Diller's startup Aereo violates existing copyright law. Hello, everyone. Welcome to your Wednesday lunch break. I'm Tanya Rivero. The Supreme Court ruling represents a significant blow to the internet streaming service and reverses a previous lower court decision siding with Aereo. What are the implications and what other companies could potentially be affected? For a closer look, we're joined by Christopher Sprigman, professor at New York University School of Law. Professor Sprigman, thanks so much for joining us.
Thanks for having me.
So a 6-3 ruling shows a clear majority of the justices sided with the TV and cable networks. Does this surprise you?
It surprises me in that I didn't think Justice Breyer would write the majority opinion, and I didn't think Justice Scalia would write the dissent. So it's a very unusual lineup. The result doesn't surprise me so much, but exactly who wrote the opinions does.
And why is that? Can you elaborate?
Well, Justice Breyer before today had really been known as someone who is skeptical of what I would refer to as copyright maximalist arguments. So, for example, he dissented in the case that considered the 20-year extension of copyright terms. He said that he thought those extensions were unconstitutional. But today he sides with what I take to be a copyright maximalist argument. Justice Scalia was not known to be skeptical of copyright. His dissent today is very skeptical of copyright.
And I'll read a little bit from Justice Breyer's opinion, saying Aereo neither owns the copyright in those works nor holds a license from the copyright owners to perform those works publicly. Now, looking forward, what could this mean to all sorts of internet providers?
So Aereo lost the case, but I don't think that's the important takeaway. I think the problem with what the Supreme Court did this morning is that it said that Aereo publicly performs these copyrighted works and so has to have a license. What Aereo does is at a conceptual level no different from what Dropbox does or what Amazon Cloud Storage does or what Microsoft or Google's cloud storage does. And so all those companies' lawyers and business people, for that matter, have to be reading this opinion this morning and shaking their heads and wondering about the future of cloud computing.
So do you think the takeaway from this case is that tech innovators need to start concerning themselves a little bit more with the regulations that are governing traditional media outlets?
Well, I think right now the cloud computing industry is probably wondering whether they should go to Congress and spend some money to try to have this opinion overturned or limited. This is an opinion interpreting the Copyright Act, so it's not a constitutional opinion. It's one that Congress could override. And I would think that if I were at one of these companies, I'd be thinking about whether that could be done.
All right. Thank you so much for that, Professor Sprigman.
Thank you.